Dear students, Namaskar. Although in my previous lecture I was discussing Article 19 of the Constitution, that article is yet to be discussed in my next lecture. So before uh, discussing the 19, I am going to share one important case law and very recent case law, and which is related to very recent problem in the society, the entire nation. That's the cases of lynching in our country. The cases of lynching, which are related to, on one hand, the incidents of cow vigilantism and cases of lynching. Once the society found that there has been a increasing numbers, or day to day the numbers are going to be increased related to these two issues. On one hand, it's the cow vigilantism and cases of lynching. It's the one case which relates to cow vigilantism and lynching. Tehseen Poonawala versus Union of India, uh, which was filed before the Supreme Court, and the Supreme Court delivered its judgment on 17th of July 2018, issuing the guidelines to curb the acts of cow vigilantism. Although the court did not address the question of constitutional validity of immunity provisions for cow vigilantes, because as we will discuss that petitioner draw the court's attention to the rise of incidents of cow vigilantism, where private citizens voluntarily punish people who they suspect of consuming beef. And all of you must have been gone through newspaper also, the various notable incidents which has been raised by the media time to time. For example, lynching of Aklak in Dadri in state of UP, who are alleged beef consumption, the hanging of two men in Jharkhand by cow vigilantes, the flogging of one Dalit in Una, Himachal Pradesh, and another, the recent lynching of Pelu Khan in Alwar, state of Rajasthan, on suspicion of smuggling of cow. So these petitioners, or the petitioners, challenged challenged the provision of cow protection. Cow protection laws of 6 states who are protecting the cow vigilantes. In the state of Rajasthan, Uttar Pradesh, Maharashtra, Gujarat, Jharkhand, and Karnataka. And in particular, they challenge the provisions that prohibit any legal action against persons for actions done in good faith under the law. For example, Section 13 of Maharashtra Animal Preservation Act 1976, which reads that no suit, prosecution, or other legal proceedings shall be instituted against any person or anything which is in good faith or intended to be done under this act, the rules made thereunder. So the petitioners challenged the provisions of this kind of provisions of cow protection laws. And on April 7th, 2017, three-judge bench headed by Chief Justice of India Deepak Misraji issued notice to the center government as well as 6 states in question. And on 13th July, the bench delivered its judgment issuing guidelines to curb mob vigilantism, and 20th August, the court began monitoring the implementation of guidelines it issued. So it's very good decision and very uh, far-reaching good decision for because for because of the uh, bobocracy. The innocent persons were subject to lynching, and here it's the court which referred the various judgments before coming to the conclusion, before coming to the its judgment. The court has referred the previous landmark judgments delivered by the apex courts. For example, the court referred the decision of St. Stephen College versus University of Delhi, where the Supreme Court emphasized on the significance of unity in diversity, The court has observed that the aim of our constitution is unity in diversity and to impede any vociferous tendencies for enriching the unity of for enriching the unity amongst the Indians by assimilating the diversities. So the meaning of diversities in its connotative expense of the term would include geographical, religious, linguistic, racial, and cultural differences. So it is absolutely necessary to underscore that India represents a social, religious, and cultural diversity. But despite of these kind of diversities, we will have to observe the unity of India, unity of nation, unity of entire society. Courts also referred another landmark decision, Sri Adi Visveshwara of Kasi Vishwanath Temple, Varanasi, and others versus state of UP, and where has lighted and religious tolerance, the Supreme Court has emphasized that religious tolerance is an important facet of unity in diversity and observed that unity in diversity is the Indian culture and ethos. So the tolerance of all religious faiths, respect for each other's religions are our ethos, are our culture. Again, the Supreme Court also mentioned or referred the states of Karnataka and another's, Dr. Praveen Bhai Thogadia, stress has been laid on the unity in diversity, treating it as the ideal way of life, considering that our nation is unification of people coming from diverse cultures, religion, and race. The Supreme Court has also mentioned that unity in diversity must be recognized as the most potent weapon in India armory, which binds the different and varied kinds of the people in the solemn thread of humanity. In this context, Supreme Court also referred the observation the state of Uttar Pradesh versus Lali Singh Yadav, where the Supreme Court had indicated that the state in India is secular and does not take sides with one religion or other prevalent in our pluralistic society. So it has no direct concern with the faiths of the people, but is deeply obligated not merely to preserve and protect society against the branches of the peace and violation of public order, but also to create conditions where the sentiments and feelings of people of diverse or opposing feelings and bigotries are not so molested by uh, ribald writings or offense publications as to provoke or outrage the groups into possible violent action. And here the Supreme Court also referred very landmark judgments which we have got discussed in our previous lectures in the light of Article 21 of the Constitution. It's that having stated about the need of tolerance in a pluralistic society, as we may refer with the Prophet that in the court in D.K. Basu's versus State of West Bengal, after referring to the authorities in Joginder Kumar versus State of UP. Another important reference was made by the Supreme Court, Neelabati Behra versus State of Odisha, etc. And Supreme Court also referred one, one its landmark judgment, that is the Arnesh Kumar versus State of Bihar. And the Supreme Court also referred, the purpose of referring to all these authorities also mentioned that the law provides a procedure for arrests, because you know that in all these cases the Supreme Court has referred that the one's personal liberty could be curtailed, person's one's life could be taken away, only the procedure established by law, other than otherwise not. So the purpose of referring of all these authorities is that the law provides a procedure for arrest and equally for investigation and consequential trial. That is why, that is what has been interpreted by this court while dealing with Article 21 of the Constitution. So, thus, the rights of the citizen cannot be destroyed in an unlawful manner. So, as the investigation agencies has to show fidelity to the statutory safeguards. Similarly, every citizen is required to express loyalty to the law and legal procedure. No one, and we repeat, no one is entitled to take the law in its own hands and annihilate everything that the majesty of law protects. When the vigilantes involve themselves in the lynching or kind of brutality, they in fact put the requisite accountability of citizens to law on the ventilator. So that cannot be countenanced. Such core groups cannot be allowed to act as they contradict the notions. They are no one to punish a person by ascribing any justification. The stand and stance put forth in the interlocutory applications filed by the implicated parties intend to convey certain contraventions of the provision of the statutory law, but the prescription of punishment does not empower anyone to authorize himself to behave as the protector of law and impose punishment as per his choice and fancy. So, here the Supreme Court held that there is no doubt the act of lynching is unlawful, but we are not concerned with any specific case, since it has become it has become a 20 sweeping phenomena with far-reaching impact. So it is our constitutional duty to take a call to protect lives and human rights. So there cannot be the right higher than the right to live with human dignity, and further to be treated with humanness that the law provides. What the law provides may be taken away by lawful means. That is the fundamental concept of law. No one is entitled to shake the set foundation. so citizen can assert the human dignity of another. For such an action would uh, comatose the majesty of law. So in civilized society, it is the fear of law that prevents crimes commencing from the legal space of democratic ethos till the legal system of modern societies today. The lawmakers try to prevent crimes and make the people aware of same, but some persons have dwelt masterly kill to transgress the law, jostle in the streets, and that eventually leads to an atmosphere which witnesses the bloodshed and tears. So when preventive measures face failure, the crime takes place, and then there have to be remedial and punitive measures. So steps to be taken at every stage for implementation of law are extremely important. So hence the Supreme Court, in the light of the prevailing circumstances of large number of cases of lynchings by the cow vigilantes, the Supreme Court hence uh, prescribes or proceed to issue the following guidelines. First of all, it's the first of all we can say it's the preventive measures. Okay, what could be the preventive measures which should be taken into account by the law enforcement agencies? First of all, the state government shall designate a senior police officer, not below the rank of superintendent of police, as nodal officer in each district, and such nodal officer shall be assisted by one of the deputy superintendent of police officer in the state for taking measures to prevent incidents of mob violence and lynching. So they shall constitute a specific task force so as to procure the intelligence reports about the people who are likely to commit such crimes. Second, the state governments shall forthwith identify the districts, subdivisions, villages where instances of lynchings and mob violence have been reported in the recent past, say in the last past 5 years. So the process of identification should be done within a period of 3 weeks from the date of this judgment. The next preventive measure, the Secretary Home Department of the concerned states shall issue a directive advisories to the nodal officer of the concerned districts or for ensuring the officer in charge of the police station for identifying the area extra cautious if any instance of mob violence within their jurisdiction comes to their notice. The nodal officer, next, the nodal officer so designated shall hold a regular meetings at least once in a month with the local intelligence units and districts along with the SHOs, etc. The Director General of Police, Home Department of concerned state shall take a regular review meetings at least quarter within all the nodal officers, etc. And it is shall be the duty of every police officer to cause a mob to disperse by exercising his power under section 129 of the CRPC, which is in his opinion has a tendency to cause violence or wreak the havoc of lynching in the disguise of vigilantism or otherwise. And Home Department of the government of India must take initiative, work in coordination with the state government for sensitizing the law enforcement agencies, etc. And said like that, that around 12 guidelines were laid down by the Supreme Court as a preventive measures. Like that, the remedial measures were also, despite of the preventive measure taken by the state police, uh, it comes to the notice of the local police that an incident of lynching or mob violence has been taken place. The jurisdictional police station shall immediately cause to lodge an FIR and without any undue delay under the relevant provisions of IPC and other provisions of law. And it shall be the duty of the SHO in which police station such FIR is registered forthwith intimate the nodal officer in district who shall in return ensure that there is no further harassment of the family members of the victims. uh, Next remedial measure, that the uh, uh, investigations in such offences shall be personally monitored by the nodal officers who shall be duty bound to ensure the investigation is carried out effectively and the charge sheet in such cases is filed within the statutory period from the date of registration of FIR or arrest of the accused as the case may be. The state governments shall prepare the lynching or mob violence victims compensation scheme in the light of the provisions of Section 357A of the CRPC within 1 month from the date of its judgment, and in the said scheme for computation of compensation, the state government shall give due regard, due regard uh, to the nature of bodily injury, psychological injury, and loss of earning, including loss of opportunities of employment and education, and expenses incurred on account of legal and medical expenses. So, the said compensation scheme must also have a provision for interim relief to be paid to the victims or the next kin of the deceased within period of 30 days of the incident of mob violence or lynching. And the cases of lynching and mob violence shall be specifically tried by a designated court, means fast track courts earmarked for that purpose in each district. Such courts shall hold trial by the case on the day-to-day basis, and the trial shall preferably be conducted within 6 months from the date of the taking of cognizance. So we may hasten to aid that the direction shall apply to even pending cases. The district judge shall assign those cases as far as the possible to one jurisdictional court so as to ensure expeditious disposal thereof. So it shall be the duty of the state government and the nodal officer in particular to see that the prosecuting agencies strictly carries out its role in appropriate furtherance of the trial. So it is again, the very very important guideline which has been uh, laid down by the Supreme Court for establishing a designated court or fast track court for handling such kind of different nature of cases that relates to the mob violence or lynching. To set up a certain example in cases of the mob violence and lynching, upon conviction of the accused persons, the trial court must ordinarily award maximum sentences, maximum sentence as provided for various offences under the provision of IPC. So again, that maximum punishment will create a little bit a deterrent effect in the uh, minds of the person or mind of the person who are having such kind of habits of to declare himself or themselves as a self-styled judicious tribunal or self-styled judicial tribunal to award any kind of punishment, including killing of an innocent person. And the victims or the next of kin of the deceased in cases of mob violence and lynching shall receive a free legal aid if he or she so chooses and engage any advocate of his or choice from amongst those enrolled in the legal aid panel and under the Legal Services Authorities Act of 1987. Not only the preventive measures or remedial measures, now the Supreme Court has laid down uh, few punitive measures also. And what are the punitive measures? Whenever it is found that a police officer or the officer of the district administration has failed to comply the aforesaid directions in order to prevent or investigate or facilitate expeditious trial of any crime of mob violence and lynching, the same shall be considered as an act of deliberate negligence and or misconduct for which appropriate action must taken against him or her, not limited to the departmental action under the services rule. The department action shall be taken to its logical conclusion, preferably within 6 months by the authority of the first instance. Uh, Another important guideline in terms of the guidelines in terms of the punitive measures. In terms of the ruling of the courts, uh, R. Mangam Sirvai versus State of Tamil Nadu, the states are directed to take disciplinary action against the concerned official if it is found that such official did not prevent the incident despite having a prior knowledge of it, and where the incident has already occurred, such official did not promptly apprehend and institute a criminal proceeding against the culprit. So the measures that are directed to be taken have the carried out within 4 weeks by the central and the state governments, and reports of the complaints be filed within the set period before the registry of the court. So we may emphatically note that uh, it is axiomatic that it is duty of the state to ensure that the machinery of the law and order functions efficiently and effectively in maintaining peace so as to preserve our quintessentially secure ethos and holistic uh, social fabric in a democratic setup governed by the rule of law. In times of in times of 2011, in times of one case, it was the case of 2011, chaos and anarchy. The state has to act positively and responsibly to safeguard and secure the constitutional promises to its citizens. So the horrendous acts of mobocracy cannot be permitted to inundate the law of the land. Earnest action and concrete steps have to be taken to protect the citizen from the recurrent patterns of violence, which cannot be allowed to become the uh, new normal or norm. So the state cannot turn a deaf. The state cannot turn a deaf ear to the growing rumblings of its people, since it's concerned, to quote Woodrow Wilson, must ring with the voices of the people. The exigencies of the situation requires us to sound the clarion call for earnest action to strengthen our inclusive and all embracing social order which would from reaffirm the constitutional faith. We expect nothing more and nothing less. So, apart from the directions we have given here before and what we have expressed, we think it appropriate to recommend the legislature that the parliament to create a separate offence for lynching and provide a adequate punishment for the same. So we have said that so as to special law in this field would instill a sense of fear for law amongst the people who involve themselves in such kinds of activities. So there can be no trace of doubt that the fear of law and veneration of the veneration for the command of law constitute the foundation of a civilized society. So, so know that it was the uh, various guidelines which were laid down by the apex court in this so sensitive case, which were filed by the petitioners. This case, was decided by the bench of Justice Deepak Misraji, A.M. Khanvilkar, and Justice Dr. D.Y. Chandrachud. And this decision, as I have cited, that this was delivered on 17th July 2018. So it was very alarming decision. I think that this decision will create a little bit awareness among us, in our society, and will become a very helping tool to curb the menace of mob violence and lynching. Thank you for today. Please, we discuss the rest of the part in our next lecture. Thank you.